The L-1 category was created to facilitate the transfer of executive, managerial, and specialized knowledge employees from a business entity located abroad to an affiliated company in the States. When applying for L-1 status, there are specific regulatory criteria that must be established and clearly documented for both the employer and the employee. On the employer side, it must first be shown that both entities are doing business. This means we need to show that your foreign company and U.S. operations are both engaged in the regular, systematic, and continuous provision of goods and/or services. Essentially, the government wants to see that your business is active on both sides of the border and doesn't amount to the mere presence of an inactive office or agent. The types of evidence necessary to meet the doing business requirement include tax returns, audited financial statements, annual reports, invoices, payroll summaries, etc. The next thing an employer must establish is that a qualifying relationship exists between your business abroad and its U.S. counterpart. More specifically, the government wants to see that the foreign company is either a parent, subsidiary, affiliate, or branch office of the U.S. entity. The types of evidence necessary to meet this requirement will depend on the nature of your business. For example, when dealing with corporations, we can submit share ledgers and share certificates to evidence ownership of the enterprise. Alternatively, when dealing with limited liability companies, it may be necessary to submit the operating agreements that detail both membership and ownership of the company. Moving on to the employee side, there are two basic requirements. First, it must be shown that the employee has been working for your company abroad for one continuous year within the 3 years immediately preceding this application. This requirement means that new hires will need to work abroad for a full year before he or she may be eligible for L-1 status. Secondly, it must be shown that the applicant worked in an executive, managerial, or specialized knowledge capacity during the 1 year of qualifying employment abroad, and that he or she will be entering the U.S. to work in the same or similar capacity. The types of evidence we like to include to demonstrate whether an employee qualifies will vary depending on the nature of employment. For all employee applicants, however, we include recent wage statements such as a T4, a W-2, or P60, plus 3 recent pay stubs. For executive or managerial employees, we will need to provide detailed personnel organization charts illustrating the applicant's high-level position, direct and indirect reports, and any other high-level authority he or she may have over a particular department, component, or function of the business. For specialized knowledge employees, we will need to include evidence of the employee's specialized knowledge in the form of educational training, industry certifications, internal company training, prior experience, etc. The L-1 category is a useful tool for foreign companies looking to expand operations in the U.S. and can even be utilized to set up shop and open an office in the States. It is, however, a very nuanced classification that is often difficult to navigate on your own. At Berardi Immigration Law, our professional staff can guide you through every step of the process and provide you with business immigration solutions necessary to grow your business in the States.